And the $5,000 that you said that you could come up with, is that when, are you taking into consideration other things, or is that just based on the sale of your home?
That's based on the sale of the home, and after I make the pay off what I need to make sure my other children are.
So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to, hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games. Like with the bailiff, you're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. I told you very specific instructions when you were here before that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail. Your behavior to me tells me that you shouldn't be around any children, much less your own. Whatever is happening with you when you're getting angry at these children with what you're doing, because it's the same. This appears to be the exact same type of incident that you pled guilty for a few years ago when I put you on the probation for the possession. And this, I mean, it's ridiculous. You and Ashley both don't need to be around any children. Don't need to be having more children. You can't take care of your own children.
Yeah, I lost a lot already, you know what I'm saying?
But you haven't lost any blood. So the person who was in the hospital, because I'm sure this person had to go to the hospital for the stab wound, right? So when they were in the hospital from where you stabbed them, they lost time with their family. They lost time with their children. If they have children, can't go to the ball game because they're in the hospital. 847, State of Texas versus John Anthony Ayala. Can I have parties announced for the record for the state,
Michael Villarreal for the state.
for the defense?
Alex Scharf for the defense.
And are you John Ayala? Yes. All right, we're here. The state has, I'm sorry, the defense has filed a motion seeking a bond reduction. State, have you had a chance to review the state defense's motion, and are you ready?
Yes, Your Honor, we are.
All right, defense is your motion.
Thank you, Judge. Call Yvette Ayala as a witness.
All right, Ms. Ayala. If you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you state your name for the record.
Yvette Ayala.
All right, defense.
Thank you, Your Honor. Ms. Ayala, where do you live?
151 Bangor.
In San Antonio?
Yes.
All right. And are you working?
Yes, sir.
Okay. Where do you work?
Commercial kitchen parts and service.
Okay. You married?
No.
Okay. And John is your son, is that correct?
Yes.
How old is he?
19.
18. He has no criminal record, is that correct?
No, sir.
Now, you know that he's charged with a continuous sexual abuse for minors, is that correct?
Yes.
Right. And that the bond is currently set at $150,000. Is that correct?
That's what I heard.
Okay. Now, do you have $15,000 to pay to a bondsman or to someone to get him out on that high of a bond?
No, sir.
All right. Is there anything, property that you own or that you can, is there an amount that you can get together of money that you could put towards a bond to help to get John out of jail?
I'm currently trying to sell my house.
Okay.
With the money that I get back, though, I'm trying to make sure I get my other kids set up. And I don't have any more vacation time to take, so when I have doctor's appointments and stuff for here, I have to take an unpaid day off. So crunching the numbers and everything, I mean, I can do like 5,000.
All right. And in the event that the bond is reduced or or you're ever able to make it, where will John be living?
With my grandmother.
Okay. Are there any minors under 17 that live there?
No. Not that I know of.
Is that your mom?
No, it's my grandma. My mom's another option as well.
Okay. There are places where he can live that
Yes,
would not violate any conditions.
yes.
Okay. Pass the witness.
Just a few questions. Ms. Al, you said you owned your own home?
Oh, I'm still paying for it, yes.
You have a mortgage on your home? Okay. And the $5,000 that you said that you could come up with, is that are you taking into consideration other things, or is that just based on the sale of your home?
That's based on the sale of the home and after I pay off what I need to make sure my other children are able, I need a place for them to live.
If you were going to sell your home, where are you gonna live?
Our plan right now is to sell our home, get an apartment. I would like to pay it for a year, because like I said, with my hours not meeting, I don't want to stress over eviction.
So the 5,000 you're considering is in part due to you want to prepay your rent. As far as if he were to make bond, regardless of the amount, you said that he was not going to be residing with you.
No, because I have my daughter.
And how old is your daughter?
I have my 16-year-old and my 12-year-old.
Okay, so you have two children under the age of 17.
I have 3. My youngest, my son is 11.
You have 11, 12, and 16, is that correctly? And they would be residing with you. I'll pass the research.
Any further questions?
Nothing further, Judge.
All right,
Pass
call
the
the
witness.
Call your next witness.
We rest.
All right, Steve.
Yes, Your Honor. At this time, say we just offer state exhibit number 1, which has been previously tendered to defense.
No objection.
All right, then states exhibit number 1 is admitted into evidence. Just give me a moment to read it. All right, the court will hear argument. Defense, it's your motion.
Thank you, Judge. After reading the exhibit that the state tendered to you, I believe that most of the allegations happened or are alleged to have happened when Mr. Ayala was a juvenile. To take that into consideration, that might have an effect on the jurisdiction of the case. 18 years old, no priors. Has a safe place to stay. I understand the seriousness of the charge. But $150,000 bond, I mean, I've seen murder cases with less than that. Stabbing, shootings, all that kind of stuff. I would ask that you reduce the bond from $150,000 to $50,000.
All right, state.
Yes, Your Honor. I guess 2 things from the state's perspective. Number 1 is just the offense in and of itself, which the court is well aware of, and the seriousness of these allegations, and the defendant's own admission to committing these offenses. The court's well aware that juveniles go to prison as well for these types of offenses. So the fact that he was a juvenile doesn't negate the age difference in this case, which I believe is, if I'm calculating it correctly, would be at least a 9-year difference between the two individuals. Secondly, in determining what is the appropriate amount to set in this case, obviously the court's taking into consideration the ability for the defendant to make bond. And so in this case, I don't believe that Ms. Ayala has demonstrated through, or the defense through Ms. Ayala has demonstrated the inability to pay, rather the inconvenience of being able to pay. She has other understandable uses and needs for that money, but prepaying a whole year of your rent, even assuming rent is $1,000 a month, that's $12,000 right there. And that's including, talking about her having to have at least 3 kids, and that would be pretty relatively safe to expect that'd be $12,000 right there. And so it's not the most convenient way for her to use her money, but obviously I don't think that should be taken into play what the court is going to consider. And so we're asking that the bond, the writ be denied, that the bond is already appropriately set at an amount based on the nature of the offense, the specific allegations of this offense, and the lack of evidence to show that the defendant has the inability to make the bond as presently set.
Defense, it's your motion, so you have final argument.
Thank you, Judge. Ms. Ayala, told the court she doesn't have the money. She's in the process of selling her house. God knows when that will happen. Or how much it'll be. But clearly she doesn't have the money to make this bond right now. She's justified to that under oath. When and if the house gets sold, depending on what it gets sold for and all that. Her son is still in jail. And he's been there for over a month, and it's his first offense, and he's been throwing up all morning. Let's get out. And we think that realistic just bond can be formulated. I believe full house arrest has already been ordered as a condition of his bond, where you can lower the bond to $50,000 and protect and give protection to the community, to the alleged victim. And so we're gonna say that we did show that she cannot make the bond right now at this moment.
All right, so this is what the court is going to do. The court is going to set the bond at $130,000, full GPS, waive fees, no contact with minors.
Thank you, Judge.
All right, are we ready on Stephanie Gomez?
Good morning. Are you Nasir Brown?
I'm not here today on special appearance.
I'm sorry, speak up so I can
Here
hear you.
here today
You're appearing here today?
by special appearance.
Okay, what is your name?
I'm a third party intervener on behalf of artificial legal entity, Nasir Brown.
Okay. At one point in your,
Again, let me talk about this.
at some point in your life prior to being this third party, were you Nasir Brown?
No,
You're not him.
I'm a third party intervener.
So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. Hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
That's relative.
So are you Nasir Lewis Brown, or have you been him at some point in your life or not?
Yes.
Okay, so I'm going to call you by Mr. Brown because I'm not going to say all the words that you just said, because you have now identified yourself as Nasir Lewis Brown. And so, Mr. Brown, this is your initial appearance, and you have 2 cases. And cause number 26, I just asked you not to speak over me. So here's the thing, Mr. Brown. I'm going to be very patient.
And at the child subject matter jurisdiction, going on record.
Your challenge of the subject matter jurisdiction is overruled. Let me go through what I need to go through, okay? So this is your initial appearance, your first day in court. I'm required to go through what you're charged with by indictment. In cause number 26, BCCR 03322, you're charged with a third-degree felony offense of assault family violence by impeding breath or circulation from February 16th of 2026. And then in cause number 26, DCCR 0323, you're charged with the state jail felony offense of injury to a child, and that's from February 16th of 2026. And so since you have made bond and got out of jail on your cases, have you had an opportunity to try to hire a lawyer?
This is what I'm saying.
Speak up so I
Been
can,
up and down.
it's been up and down?
Yes.
Okay, so here's what I'm gonna do, Mr. Brown, is I'm just like everyone else, I'm resetting your case about 30 days to give you some time to try to hire a lawyer. You need to try to get someone hired before the next court date. If you do, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to, so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? I'm sorry,
Overstaying.
say it
They
again.
overstaying.
You overstand?
Yes.
Okay, what does that mean?
Overstaying.
Do you understand what I'm saying, sir?
I'm blind.
You'll
I'm blind.
oblige.
I'm blind. Yeah.
Okay. You just determined to use different words and be difficult, aren't you?
No.
Okay. So as a condition of your bond, did you have a condition that you were not to have any contact or communication with the complaining witnesses in each of these cases, right? Okay, and so I want to make sure you understand the importance of that. And that if you do have any contact or communication with either of them, it would be a violation of that bond condition. If I find out, your bond would be raised and you would go back to jail. Do you understand that as well?
Overstaying.
You overstand.
Same thing.
I'm going to guess that overstand is even better than understand. So you definitely know what I'm talking about, right? So we don't have any miscommunication today. You know exactly what I'm talking about. So I'm going to have you step in front of the clerk. You're going to sign a reset notice so you know when to be back in court and take care of those things before the next court date. All right, step in front of the clerk. Nasir Brown. Are you Nasir Brown? I'm sorry.
We were here before.
You've been here before, but you have to speak up where I can hear you.
Executing beneficiary of the trust in hand.
Of the trust of what?
Of the trust in hand, yeah.
Of the trust in hand? Whose
Yes.
hand? What trust?
The execution.
Did you bring a copy of it?
I wasn't able to get to the copy. I do have.
Take the glasses off. I need to see your eyes, please.
These are my prescription glasses.
That's okay. So I'm having a hard time understanding you. You need to speak up and speak clearly so that the record can be clear. You were already here and I gave you an opportunity to try to go hire a lawyer for your 2 cases. Did you get a lawyer hired?
Able to do it.
Who'd you talk to?
Made a few calls to the guy, Rafe. What's his name? Rafe King?
Mm-hmm.
Wasn't able to get through.
Who else?
That's the lawyer that I chose.
So if you chose him, you should have gotten him high. I mean, he has the same, there's somebody that answers his phone every week. I understand. I know how it works. I told you to hire someone or visit with at least 3 lawyers.
Made an attempt.
You made an attempt? Okay, did you go see Mr. Kimler? Did you make an appointment?
Able to do that.
Why not?
I'm not in a position to go back and forth in front of a lawyer that's in this state that I'm not from. This is foreign age.
So here's the thing, Mr. Brown, I told you very specific instructions when you were here before that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail, right?
No.
Yes, that's exactly what I say, because you've heard me say it probably 8 times already this morning. So at this time, Mr. Brown, because you did not do what I asked you to do or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen, Mr.
Yeah.
Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're gonna make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Go back with the bailiff.
She started,
Don't make me lay hands on you,
why would you lay hands on me?
because you're not doing it, I'm telling you, now go. She's
Mr.
telling
Brown,
you that she go
You
back.
need to go back with the bailiff. Right now, I've raised your bonds. You have to go with the
I am not
bailiff.
a threat to any officer.
You through in, Judge?
Yes, I'm through.
I am not a threat to any officer.
Let's go.
Why are hands on me?
Yeah.
Why are
I
hands
told
being
you, I told you I was gonna put hands on you.
Why are hands being put on? Do y'all see this on the camera?
And right there, put your hands on the wall. Put your hands on the wall, because you're not listening. Don't listen. I don't advise that.
In the back that I think we need to put on the record with regard to the case and where we are. We have, first of all, sir, your Dalvius Williams. And Mr. Williams is here with Mr. Rojas. Mr. Smith is here on behalf of the state. There is a second amended motion to revoke unadjudicated probation. So because the new allegation, I'm not going to accept the plea agreement of the cap of 4 years because there's a new. So I will allow, if Mr. Williams wants to withdraw his pleas of true to 1, 2, and 3. I can go through those again and get pleas today on those, and then we can go forward with what we have today. And then if I feel like there needs to, it's my understanding, Mr. Smith, for today, you have witnesses with regard to proving up count 4 only. Is that correct?
That's correct.
So what we can do today, depending on what those pleas are, either way, we'll go forward with what we have because there's witnesses here. And then if I feel like I need to postpone the hearing to another date for the state to prove up more, then we can do that then. So, Mr. Williams, the best you can, I need you to raise your right hand, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You can put your hand down. And so, Mr. Rojas, what is y'all's position?
Judge, I think after discussions with Mr. Williams, I think he would like to withdraw his plea of true to count number 3.
Okay. So just to go back, count 1, Mr. Williams alleges that you violated your probation by failing to report to the probation department October 25th and December 15th of 2022. You had previously pled true that that was true. And do you want to continue to plead true to that count?
Yes, ma'am.
Okay. And then count 2 alleges that you're behind in your court-assessed fees as of January 4th of 2023 in the amount of $3,638. You previously pled true to that count. And do you want to continue with your plea of true to count 2? Count 3, which was in the added in the first amended motion, alleges that you committed the offense of evading arrest or detention July 14th of 2024. You had previously pled true to that count, and do you want to change your plea of true in that count?
Yes, ma'am.
You want to change your plea to not true?
Yes, ma'am.
Okay, so we'll enter a plea of not true to that count. And Mr. Smith, I know you weren't prepared, I guess, for that, but have y'all had any contact with the officer? I would think that would be a one witness.
It's actually several witnesses,
Okay.
Judge. They're going to serve a warrant at his house. There were 2 officers in the back that see him come out of the back of the house.
Okay.
Knocking on the front door, so we need both of them.
Okay. Okay. All right. So we'll see where we get today then. Mr. Williams is on probation for possession of a controlled substance, and that, which was a 3rd-degree felony, correct? No. That's been, oh, it was as well. I've got the indictment pulled up from the injury to a child. That's a 3rd-degree felony. But that possession of a controlled substance is a 3rd degree as well. So the range of punishment is between 2 years and 10 years. And Mr. Williams, I also want to make sure you understand that if we go forward with this motion and I do end up revoking your probation, then later, if the state does so we have the injury to a child, that new case, if you're found guilty in that new case, then the punishment could be stacked. Do you understand? Do you understand that? Okay. Mr. Rojas, you've gone over all of that with him, correct? And it's also my understanding that y'all had, even in the back, Mr. Williams' mom in the back to go through everything, what his options were and all of that this morning. Is that correct as well? Okay. What if any offers? I want to make sure Mr. Williams on the record rejects anything that's been offered.
We had offered 4 years in this case, Judge, and he is rejecting that offer.
Did that include an offer in the injury to a child?
Actually, I offered 4 years in both cases to run concurrently.
Okay.
If he went today.
Okay.
He said no. And I told him that if he didn't do that, if we go to trial on the new one, I would move to stack that case on whatever he gets in this case, and the 4 is off the table on this case.
Okay.
I apologize, Judge, and I didn't hear what the last part. Did Mr. Smith talk about the 4-year offer for today to the possession of a controlled substance? And if he were to be tried in the future, if he were to be convicted for the injury to a child, that case would be stacked? Did you say that?
He would request it, and it's up to me. So anytime the state asks for a case to be stacked, it's up to the court to do that. So it's not up to a jury. If you go to a jury trial on that injury to a child, what would happen? Let's say you go forward today, we have this hearing. If I revoke your probation and give you any time in prison, then the next step would be to set that injury to a child for a trial. And then if you're found guilty in that case by a jury, then what the state is saying is that they would ask me then to stack that, whatever sentence you might get, if you get a sentence, on top of what happens today in the motion to revoke probation. Do you understand? Okay. And so your options are today, if you wanted to go forward with a plea in both of your cases, plea of true in that motion to revoke for a 4-year sentence, plea of guilty in the new injury to a child case for a 4-year sentence, with the agreement that those sentences would run at the same time. You don't have to do that. We've got witnesses here. We'll go forward with the hearing. Just want to make sure you understand what your options are today that you won't have after today, and what your consequences could be if you go to trial and if we go forward. And nobody's trying to talk you into anything. I just want to make sure you understand it all. Does that make sense? Okay, so you understand everything that's been offered and what you could do today and kind of where we're about to go, right? And so what do you want to do?
True to first, but not to the injury to the child.
Okay, then we'll go forward with this hearing. So I want to make sure also for the record, what all I've reviewed. The original PSI, obviously from being placed on probation, is included with the updated pre-sentence report. Everyone should have that as well. And so when I went back through that, I just want to make sure that there aren't any corrections or issues with regard to that criminal history specifically that I'm looking at. It starts on page 1 and then carries on to page 2 on that pre-sentence, or actually it was a post-sentence investigation, I think. Y'all have that? Everybody's on the same page as me?
Yes.
So it looks like there was adult misdemeanor history of 2 thefts back in 2013. Both of those were 30 days in jail. There was a theft of services in 2014 where Mr. Williams received a probation. That probation was revoked in 2016. That's in Rusk County. Possession of marijuana in 2014, Nacogdoches, 3 months in jail. A resisting arrest or search, March of 2015, where there was a probation given that was revoked in 2018. There was then a 2015 failure to appear bail jumping case in Nacogdoches. 2016 burglary of a vehicle, 30 days jail, and then 2019 a resisting arrest again and an evading arrest also in 2019, both with 180 days in jail. Then the felony criminal history I show is a criminally negligent homicide from 2017 where a probation was given in 2018. That probation was revoked in 2020. Looks like that probation was revoked based on, and looking back on all of this, I'm not real sure other than what we were all thinking, but it looks like on January 10th of 2020, the probation was revoked on the criminally negligent homicide. There was a new offense of injury to a child that he appears to have pled guilty on and received a 12-month state jail sentence. There was another offense, new offense, from January of 2019, an attempt to take an officer's weapon, also same disposition date of January 10th of 2020 for the 12 months in the state jail. And then there was this possession case that we're here from that same date. So it looks like he took some time on a couple of things and then got probation on the possession. Does that, everybody on the same page as that?
Yes, Your Honor.
I did look back. I think because I have this information, I don't think it's necessarily improper for me to look at some of the information based on those cases. I do have a question specifically with regard to the injury to a child from 2020 that he pled guilty on. What is the relationship with, I was the victim in that offense?
It's the stepson, Your Honor.
So Ms. Broussard has other children
Yes.
that are not from Mr. Williams.
At least one, Your Honor, yes.
So when we went back through, Mr. Williams entered pleas of true to counts 1 and 2. So I am going to find, based on those pleas, counts 1 and 2 true. Count 3 entered a plea of not true, as well as on count 4. I am going to find, based on the evidence presented today with regard to count 4, that there is sufficient evidence to find count 4 true. And at this time, I am going to find count 4 true. I understand everyone's position. I think with regard to, there'd be different evidence, I would think, and probably more potentially at a trial. I'm not required to look at all that. And obviously the level of the burden is different. So count 4 is true. Mr. Rojas, you may proceed with argument.
Judge, when we did the initial plea, we got the updated PSI report. And they were recommending that if probation were to be granted of ISF. Obviously, that can't happen with a new charge pending. He does have this new injury to a child that after speaking with the family, I don't think he's going to be able to bond out even if you were to keep him on probation. If the court is inclined to keep him on probation without ISF, we ask you to do that. If that's not going to be possible, Judge, we ask the court to consider something in the range for the possession case, 2 to 4 years.
All right. Thank you, Mr. Rojas.
Judge,
Mr.
I
Smith?
believe his criminal history shows fairly convincingly that he is unable to successfully complete probation. A convicted probation officer, I don't believe it's their desire to keep him on probation with this type of charge pending, especially in light of the fact that he's already been convicted of injury to a child within the last few years. That tends to me to show more than just a pattern, it's a habit. The fact that he doesn't respect authority is shown by the jail incident reports. I feel like he needs to be revoked in this particular case, and we're asking for no less than 5 years, somewhere between 5 and 10 years as punishment in this particular possession.
Thank you. And also, just for the record, everybody has those jail incident reports. Those were provided. I've reviewed those as well. Mr. Barksdale's here. Mr. Barksdale, do you, the probation officer, do you have anything to add at this point with regard to your position?
No, ma'am, I concur with the district attorney.
Okay, thank you, sir. Mr. Rojas, I would give you an opportunity if you want to. We can ask Mr. Barksdale to come if you have any questions of him.
No, Judge.
Okay. And Mr. Williams, you're 30 years old? You just turned 31. So I appreciate that you have support here and people here to support you, but your behavior to me tells me that you shouldn't be around any children, much less your own. Whatever is happening with you when you're getting angry at these children with what you're doing, because it's the same. This appears to be the exact same type of incident that you pled guilty for a few years ago when I put you on the probation for the possession. And this, I mean, it's ridiculous. You and Ashley both don't need to be around any children. Don't need to be having more children. You can't take care of your own children. And you're disciplining them by doing this. And I don't think there's any reason for anybody to believe that no one said these are scratches. That's not what the doctor said. If there are, they're adjacent to these other marks on the back of this 2-year-old. Going to find, again, that you entered your plea of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find count 4 true. Find sufficient evidence at this time to find you guilty of possession of a controlled substance. I'm going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. I'm making a notation on this because originally it was a plea agreement that when it was signed, I'm making a modification. Let me change it. This was not a plea agreement, so you do have some rights to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Rojas. Thank you all. I'm sorry. I know this is difficult for everyone, but I have no doubt in my mind that Mr. Williams, not just on this occasion, but probably on many, has obviously improperly disciplined, if that's what you want to call it, all of these children. So, court is adjourned.
All right, the court is calling 2021 CR 10249, State of Texas versus John Robert Garcia. Can I have parties announced for the record for the state?
Michelle Hayden for the state.
And Ron Ross for responding.
Are you Mr. Garcia?
Yes, ma'am.
All right, you entered a plea of no contest on March 29th. And you entered a plea to, just one moment. You entered a plea to aggravated assault with a deadly weapon. According to the plea bargaining agreement, punishment is to be assessed at a cap of 6 years. There's a $1,500 fine. There's an affirmative finding of deadly weapon, and the state is remaining silent on your application. And there's an affirmative finding of family violence and no contact with Michael Lopez. All right. Defense and state, did you have a chance to review the TAP evaluation that was prepared?
I did, Judge.
Yes, Your Honor.
Any objections to the TAP evaluation from either the state or the defense?
Not from the defense.
No, Your Honor.
And then defense, did you receive a copy of the victim impact statement?
I did, Judge.
All right, the state is silent. Defense, you may proceed.
Judge, my client here, John, is 28. Doesn't have any prior felonies. I think he's got maybe 1 or 2 DWIs, maybe a graffiti case. He has 4 children, 8, 6, 5, and 3, or something, 2 different ladies. He's under child support order to pay. He's had a job. He reports that he has been paying child support. The altercation involved a brother. It wasn't some innocent. His brother's innocent, but it wasn't some just bystander he didn't have knowledge of. I'm asking the court to give him deferred adjudication, give him a chance. He's 28, no priors, redeem himself. I would like to ask him a couple of questions if I might.
All right, if you raise your right hand. Do you solemnly, raise your right hand? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
John Robert Garcia.
All right, defense.
John, you understand the charge that you have here, you could be put in jail up to 20 years.
Yes,
And you understand, you asked the judge to give you deferred adjudication. That's a special kind of probation that if you violate, then the judge could put you in jail for the full 20 years. You understand?
yes,
Was I correct? Was I accurate when I told the judge that you had a job, you have children, you're under child support order
yes,
for the children? Is that right?
yes, yes, sir.
Were you making child support payments before you got arrested?
Yes, sir.
And what kind of employment did you have?
I'm a cook.
Think you can go back and get a job?
Yes, I can.
If you put on probation?
Yes, I can.
And this incident involved a knife, correct?
Yes, I did.
And your brother?
Yes.
Just tell the judge, if you would, why you're asking for probation, deferred adjudication, why you think that you ought to receive it. Would you explain to the judge? She wants
Your
to hear
Honor,
from you.
let's start off by saying I know probation is a privilege, and I know that I can meet the terms and conditions of the probation. This is my first violent offense. I'm not a violent person at all. And this day it plays over in my head. I wish it could have happened any other way.
Well, you say you're not a violent person, but you heard for aggravated assault with a deadly weapon. Who did you touch?
That's my brother,
Okay.
my half brother.
What, I don't want to go into facts, but y'all went in an argument when this happened, right?
Right. And we have a rocky relationship, so it's always ended somewhat of us getting in arguments and stuff like that. So I just want to state that as well.
Did you graduate from high school?
Yes, I did.
Okay, so why do you think you ought to be given a chance? I mean, you told the judge you have no prior
Right. I've been
record.
thinking I should give him the chance because I know I could complete the probation as well. It also breaks my heart because I don't like my children to see me in jail. And they have many questions on why I'm here. And I don't want them to see me go to prison either, Your Honor. So I'm asking if you please give me a second chance.
I pass the rules.
No questions.
With that, Judge, I would ask you to consider deferred
Well, what
adjudication.
were they arguing about in the car?
You're gonna have to tell the judge.
What were we arguing about?
Mhm.
Past situations that occurred. Usually when we hang out, he brings them up. I don't really like to talk about the situation, but it was just about things from the past that he still heated on, that he still has anger toward me about,
But he didn't stab you.
no.
Let me ask you this. Had you had anything to drink that day?
Earlier in the day, yes.
Do you know if your brother, I mean, I'm not asking you to speculate. Do you know if your brother had anything to drink that day?
Yes, he did.
In your mind, were you intoxicated?
No, I wasn't.
Was he intoxicated?
I believe he was.
Did he make any aggressive actions toward you?
Yes, he did.
I think, Judge, I think the police report reflects that my client had said at the time his brother attacked him first, not with a weapon, but physically.
According to the stipulated evidence that the court has, it says, witness two and neighbors were outside, told police that they saw S1 flee the area running past them, coming from where victim one was laying on the ground. Witness to a neighbor said that suspect one ran behind the backside of the building. When Officer Hernandez went around the building, she found S1 who matched the description given by W2 and neighbors. S1 had blood on his shirt and hands to include the knife in his possession, which he used to cut victim one, which also had blood on it. Witness one came back to the scene where he told the police that he was the driver of the vehicle, where S1 was in the passenger seat and victim one was in the back middle seat giving directions. Witness one said that suspect and victim one were arguing back and forth when victim one said for W1, which is the witness, to stop the car to get out. As W1 was exiting the vehicle, witness one said that suspect one, which is your client, reached back with a knife and cut victim in the abdomen. Witness one said that's when he heard victim one say, "He cut me, I'm bleeding." He saw the blood and began to apply pressure with a t-shirt. Witness one said that is when S1 took off south from the location on foot.
That is correct, but I believe it's somewhere in the police reports. He said that his brother had attacked him first. I may be wrong, but
None of this occurred in the vehicle at all.
Okay. All right, the court is going to deny the application, find the defendant guilty. There's an affirmative finding of family violence. There's to be no contact with Michael Lopez, $1,500 fine, time and money to run concurrent. The punishments be assessed at a cap of 6 years. Would you like to speak to the counsel?
I would, Judge. I would, again, I'll let you consider everything you've heard today. And I don't think he's been to prison before, and I don't know if he's been to jail very long, except for this time right now. And I think that anytime you give him 2 years, 3 years, 4 years is going to be a real wake-up call to him. And he's going to have additional child support accruing while he's in jail. He's going to have to get out and pay to start supporting these kids. And he's young. And I'd like for you to do, give him what you give him a minimum possible that you could for in prison. Again, I think if he's going to wake up, he's going to wake up now. Even a year or 2 years, he's going to wake up. So,
All right, Mr. Garcia, how much time do you think you deserve
Your Honor,
for stabbing someone in the stomach?
I'm not too sure. I mean,
Well, I mean, surely you have a thought on what type of sentence you think you deserve. I mean, you were here asking for deferred adjudication. That's been denied.
Yeah.
So now I can sentence you anywhere from 2 to 6 years in prison. How much time do you think you deserve for stabbing your brother?
Your Honor, I don't know how to answer that question,
what would you ask the judge for?
I would ask the judge if she could possibly give me maybe, 3 years, maybe, I'm not sure, I don't
But do
know.
you deserve 3 years? Or do you deserve more than that? That's my question to you. Some people will come in and some people will say, you know what? I think I deserve 2 years.
Yes, ma'am. Well, I don't know. See, the way I feel is, I don't know, I feel bad for the situation, like I really do. No amount of time could change what I did, because
No, it can't.
I broke a bond, you know what I'm saying?
Mhm.
I could never get back. So to me, I lost a lot already, you know what I'm saying? So,
But you haven't lost any blood. Because the person you stabbed lost blood. So when people are taken away from their families, they're like, I lost time with my family. So did the person who was in the hospital, because I'm sure this person had to go to the hospital for the stab wound, right? So when they were in the hospital from where you stabbed them, they lost time with their family. They lost time with their children. If they have children, can't go to the ball game because they're in the hospital. If they're walking around carrying their children, can't walk around and carry my child because I've been stabbed. Can't have my child running towards me where I lift him up because I've been stabbed. I got staples or stitches or whatever. So when I ask people what time do they deserve, I'm not asking you about how this is going to affect other people in your life, how it's going to affect your children. I internalized what you said about, or at least your counsel said about, I don't want my children to see me in jail. Hopefully your children have not been visiting you in the jail. Excuse me, miss, there's no phone use in the courtroom. So what time do you think you deserve?
I think 3 years for me would be a wake-up call.
Why do you deserve 3? Why not 6?
I haven't been in trouble, Your Honor. 28 years of my life.
I haven't been in
And
trouble
I
either.
did change my life. Well, we come from different backgrounds. I come from a hard upbringing.
You don't know where I come
And
from.
I did change my life, Your Honor.
There are a lot of people who have a hard upbringing, and guess what? They've never been arrested, never been in jail, and never stabbed anybody. Now, I do understand that people have different upbringing and everybody has their own path, and I understand that people walk in different shoes. And what may affect you a certain way may not affect me the same way.
Right. I
But
came a
there are
long way,
plenty of
Your
people
Honor.
who've had hard lives.
I came a long way and I changed so much.
What's up with the tattoos on your face?
Uh,
What is that?
Got them when I was younger.
What is that a tattoo of?
It's my daughter's birthday.
You can't remember that?
I can't put it.
All right, that's your daughter's birthday up there. I'm talking about on the cheek. What is that? That is not a numerical birthday.
It's a SA,
Essay what?
San Antonio.
You can't remember where you live?
I can't.
All right. Court's gonna sentence you to 6 years in prison, give you credit for any time that you serve. There's to be no contact with Michael Lopez, $1,500 fine, time and money running current. Is there restitution at all?
Your Honor, I don't believe we have a figure. I can check the system, but I don't have an exact figure for you.
All right, then there's restitution, if any, to Michael Lopez. I'm going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal. I'm sorry, just one moment too. There's also an affirmative finding of deadly weapon. So that the record can be clear, Brenda, this is the complete record. $1,500 fine, time and money running current, 6 years in the prison, credit for any time served. There's an affirmative finding of family violence, an affirmative finding of deadly weapon. There's to be no contact with Michael Lopez, and restitution, if any, to Michael Lopez. Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because there's an affirmative finding of family violence, and also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes.
All right, good luck to you.